Good evening, everybody, or good morning, or good afternoon, whatever time you're watching this. This is a very brief video. I'm going to be taking you through the small claims process and just bullet point some key issues that you need to be aware of. This is not intended to be any legal advice. It's just a brief outline of how the small claims process works. So, just to be clear, this is what a claim form should look like. And you can fill one of these out online, or in the alternative, you can also download and print one and fill it out as well, or you can download it, type it up, type into it, and of course you can post that as a paper document and email it if you want to, or you can simply save it, essentially post it or email it over by one method of service. Now, in terms of the small claims track, this is intended to deal with cases that are not worth more than £10,000 and are normally going to take a few hours for the court to resolve. Now, they're designed to be relatively informal. However, there are some key points that you need to be aware of when dealing with a small claim. And make sure that if anyone has received any of these forms, particularly this claim form, that the party bringing the claim against you has complied with the pre-action protocol. Now, these are things like ensuring they provide you with a small claims letter before action or letter before claim. Now, this should look something like one of these when it opens up. This effectively should be a letter stating that this will be the final letter before action, following things like late payment for debt recovery and so on and so forth. Now, you can obviously get templates and so on of these, but they should be headed something like this. Now, in terms of the small claim itself, if you don't receive a letter before action, then when the claim is brought against you, you are well within your right to raise this with the judge. And this is, of course, if you genuinely did not receive a letter before action. You should receive some clear correspondence headed LBA or letter before action, so make sure you look out for that. Now, if you've received one of these claim forms, there should be your ability for you to submit a formal defence and potentially even a counterclaim as well. But if you receive one of these, you need to make sure that you are acknowledging them as a bare minimum, and then as a result of that, you are completing a defence and ensuring that you send that off to the party at their address. Now, again, there's two processes to bear in mind when you receive a claim form. If you know that you owe the debt, of course, don't just try to defend it with the idea that you might be able to just simply get away with it. Because if the claimant can prove clearly, and you know that they've proven that they owe the debt, you could become liable for not only fixed costs, which are the costs of the court being, for example, the solicitor's costs on issue, the hearing fee, and then the court issue fee, which are normally between £350 to £500. You could also be liable for legal costs pursuant to a rule under Civil Procedure 2714 2G. That's Civil Procedure Rule 2714 2G. And this would mean that you might have to pay fees of attendance, legal costs, solicitor's costs. So please bear in mind, if you know the debt is due and owing, try to get in contact with the company, try to make some sort of payment plan if you can. Look, it's not for me to tell you what to do. However, matters that are resolved away from court inevitably tend to be far less expensive. But going back to what I was saying, if you know that you don't owe the debt, you can file a defence, set out your position, and then after this the court will send you out a court order, document entitled court order, by which it will clearly state that you need to file a witness statement with any evidence upon which you intend to rely by a certain date. Now, just one final point in terms of representing yourself. If you are the defendant, you're more than entitled to represent yourself, bring your case out, provide a witness statement, make sure your witness statement is signed and dated with a statement of truth. Statement of truth, you can just have a look online and you'll be able to easily see what a statement of truth looks like. It's just a paragraph stating that effectively you're not seeking to mislead the court and the contents of your witness statement are true to the best of your knowledge and belief. If you do want somebody to represent you, you can make an oral application, basically say to the judge that you'd like a party to represent you with you obviously being present, and they can do this under the court's general discretion under Civil Procedure Rule 27.9. And of course, they can represent you with you there pursuant to the lay representative's order as well. Now, this is just a brief insight to small claims. Of course, each claim is based on its own merits and will have its own complicated set of events. However, please look out for these guidelines and make sure, like I said, you're complying with the letter before action, pre-action protocol, and if the claim is being brought against you, you've received the letter before action or pre-action protocol in line with the pre-action protocol. Make sure that you acknowledge the claim form and file a defence if you need to. Make sure you complete the information clearly. And of course, if you need representation, make sure that you are present and you ensure that you acquiesce to that representation being present and acting on your behalf, as long as the judge allows it. Well, look, thanks for your time. Appreciate you taking the time to watch this video. Hope that helped. Any questions, don't hesitate to pop them in the comments. And first and foremost as well, or should I say lastly, don't forget to hit that like, comment and subscribe. Have a good one, guys. Take care. Bye-bye now.